Hearing in the appeal, Commissioners for Her Majesty's Revenue and Customs against NHS Lothian Health Board.
Yes, Mr Thompson.
I'm obliged, my Lord. On behalf of the appellants, the Commissioners for Her Majesty's Customs and Excise, I invite the Court to allow this appeal, to recall the interlocutor of the First Division of the Inner House of the Court of Session dated the 9th of April 2020, by which interlocutor that Court set aside the decisions of the First Tier Tribunal and the Upper Tribunal and remitted the taxpayer's appeal to a differently constituted First Tier Tribunal for reconsideration, and thus finally to reinstate the orders of the First Tier and Upper Tribunals which had refused the taxpayer's appeal. As is set out in the written case for the Commissioners, the present appeal broadly raises 4 issues. Those are, first, the role of the First Tier Tribunal in appeals of this kind and the approach which that tribunal should take to evidence in what are generally referred to as Fleming claims. Secondly, the impact of the EU law principle of effectiveness upon the burden of proof in such cases. Thirdly, the effect, if any, of what has been termed state fault upon the approach to be taken to the evidence in such cases. And fourthly, and ultimately, whatever the answer may be to the first 3 issues, whether on conventional appellate principles the Inner House had a proper basis for its conclusion that the tribunals below were not entitled to refuse the taxpayers' appeals on the grounds given by them. Those reasons, I should say, were first, in the case of the First Tier Tribunal, as essentially set out at paragraphs 194 to 196 of its judgment, that it found evidence about the general level of activity providing business supplies and their nature not to be sufficiently precise for use as a basis for quantification of the claim throughout the relevant period, that being the period from 1974 to 1997, and that the taxpayers' proposed method of extrapolation as the basis for apportionment to identify the residual input tax was, as the tribunal put it, not reasonable or acceptable. In the case of the Upper Tribunal, paragraphs 20 to 21, it identified that the First Tier had correctly identified that the question that had to be answered was whether the taxpayer's proposal for business, non-business apportionment was a reasonable one. Having found there was no reliable means of calculating the business income received by the laboratories during the Fleming period, the First Tier went on to consider the alternative method of calculation proposed by the appellant. That was the use by extrapolation of the percentage from 2006-7, which method, as I've mentioned already, the First Tier considered not to be reasonable or acceptable, such that the Upper Tier considered that the First Tier had identified and answered the correct question. The Upper Tribunal also observed, for reasons it had given in a previous appeal between these parties, that there had been no breach of the EU law principle of effectiveness. Now, so far as the EU law principle of effectiveness is concerned, a good deal of authority on that subject has been put before the Court in this appeal, some of which I will address in these submissions. But I should highlight at the outset that in my submission, a striking peculiarity of the present case is that in my submission, no rule of domestic law, procedure or evidence was actually identified by the Inner House as having the effect in breach of the principle of effectiveness, of rendering impossible or excessively difficult the exercise of the taxpayer's right to deduct input tax, the EU law right to deduct input tax. And further in my submission, even now, the taxpayer has still not identified before this Court any such offending rules of domestic law. And indeed, it's common ground between the parties to this appeal that The onus of proof was upon the taxpayer in respect of its appeal to the tribunal, and that the applicable standard of proof was the usual civil standard of proof on the balance of probabilities. And what one will see in my submission is that on an analysis of the EU law principles and authorities, the rejection of the taxpayer's claim, both by the commissioners and by the tribunal, gave rise to no breach of the taxpayer's EU law rights. There are four further points I would mention at this stage by way of headline, as it were. The first is this: where inputs have been used for purposes other than taxable transactions, an apportionment of the input tax claimed is required. That apportionment is a substantive rather than a formal aspect of the right to deduct. In the case of EU law, Article 174 of the Principal VAT Directive prescribes a particular basis on which that apportionment, and thus the calculation of the deductible proportion, is to be undertaken. In UK domestic law, a similar provision is made in Section 24. So the headline is that the apportionment of the deductible input tax in the case of residual input tax is a substantive element of the right to deduct. The second point to mention at this stage is that taxpayers' Fleming claim in respect of unrecovered input tax in the present appeal is not a claim for tax which has been paid or overpaid in breach of EU law rights. And in my submission, that is important because many of the cases founded upon by the taxpayer in this appeal are concerned with that type of situation. San Giorgio perhaps being the paradigm of that, a tax levied in breach of EU law. And in my submission, the approach of the Inner House, likewise, was heavily influenced by such authorities. And one will see in the opinion of the First Division a repeated reference to tax overpaid in breach of EU law. So that's not the claim before the tribunal and thus ultimately before this court. Rather, it is a late claim for recovery of input VAT that was not previously claimed. Thirdly, and I've to some extent touched upon this already, the EU law principle of effectiveness in my submission does not assist the taxpayer in the present case, and that's because there is no rule of law, procedure or evidence which has rendered impossible or excessively difficult the exercise of the taxpayer's EU law right to deduct input tax. Far less is there any such rule that has done so in a disproportionate manner. And the fourth introductory headline I give to the court is this: that although the weight of the submission for the taxpayer before the Inner House of the Court of Session, and indeed in its written case before this court, was and is heavily dependent upon the proposition that the evidential difficulties faced by it arose as a result of what it characterises as state fault. In my submission, it's important to note that there is no trace of that case having been made by the taxpayer before the first-tier tribunal. And indeed, not only was there no case of state fault being made before the first-tier tribunal, it rather appears that arguments based upon the EU law principle of effectiveness first were advanced by the taxpayer before the upper tribunal rather than before the first tier. And in my submission, for reasons which I'll come on to address more fully, the failure to advance a case of state fault before the first-tier tribunal is important for two principal reasons. And the first is that the evidence before the first-tier tribunal, in my submission, was necessarily directed towards the issues that were then in dispute before that tribunal. And state fault was not an allegation that was being levelled against the commissioners at that stage, with the necessary result that the evidence before that tribunal was not directed towards that issue, and findings in fact were not made directed towards that issue. The second important consequence of that failure in my submission is that, and this applies not just to the state fault issue, but also to the fact that a case based on a breach of the principle of effectiveness was not advanced before the first tier, is that in my submission it's not fair to criticise the first tier's judgment and its reasoning on the basis of arguments that were not before it. And nor in my submission is it appropriate to put a gloss on findings made by the first tier in one context to support a case that was not actually being made before that tribunal. That tribunal, of course, being the principal trier of fact. With that general introduction and those headlines, I should explain that there will be broadly 5 chapters to the submissions which I make to this court, and I take them in a slightly different order to the order in which they're set out in the written case for the Commissioners. The first issue I'll seek to address is the European and domestic law on the right to deduct inputs, including the type of deduction claims in the UK which have come to be known as Fleming claims. And I take that issue first because in my submission it will help to inform the subsequent analysis of the remaining issues. The second issue, the second chapter, will address the principle of effectiveness. The third will look at the role of the tribunal in cases of this sort. The fourth will consider the issue of state fault. And then fifthly and finally, I'll look at the findings of the first tier tribunal and the errors in my submission which are manifest on the face of the opinion of the First Division of the Inner House. So I turn then, first of all, to the chapter concerning the law in relation to the right to deduct and Fleming claims. And there are, because this chapter addresses both the EU law and the domestic law, I'll need to look first of all at the Principal VAT Directive provisions, secondly at some of the case law of the Court of Justice, and finally in relation to some of the domestic law. Now, so far as the directive is concerned, the main provisions are set out at paragraph 27 of the Commissioner's case, pages 70 to 71. Of the bundle. The first thing to note is that Article 167, and so the court has the reference, Article 167 is at page MS 1534. So that provides that the right of deduction arises when the deductible tax becomes chargeable. That's the primary right of deduction. And then Article 168, also at page 1534, begins with the important words of qualification. Insofar as the goods and services are used for the purposes of the taxed transactions of a taxable person, the taxable person shall be entitled to deduct from the VAT which he is liable to pay, A, the VAT due or paid in that member state in respect of supplies to him of goods or services carried out by another taxable person. So the critically important point in my submission there is that looking at the language of Article 168, subparagraph A, what it is that can be deducted is the VAT due or paid, read short, in respect of supplies of goods or services to the taxable person. In other words, what it is that may be deducted is a definite sum, and that is the substantive content of the right to deduct. As we'll come on to see in a moment, in the case of residual input tax, there has to be an apportionment to identify that definite sum, and that apportionment is also a substantive element of the right to deduct. And the reason for laying emphasis on this definite sum at this stage in my submissions is this, that there is a flavour in my submission in the case for the taxpayer, and indeed a strong flavour in the opinion of the First Division, that the right to deduct had been established as the taxpayer would have it and as the First Division would have it, and one was now at the stage of mere quantification.
Yeah, I think the way Lord Drummond-Young puts it in his elementary logic paragraph is that you can have a valid claim without having quantified any amount.
Precisely. And picking up on my use of precisely, I say that's wrong because there has to be a precise sum. Because what it is that can be deducted is not an abstract principle that VAT can be deducted, but it's the amount of VAT due or paid. And in the case of residual input tax, the apportionment is a substantive element of the right to deduct. And indeed that, in my submission, lies at the heart of the appeal, that there is no right to deduct, in my submission, until all of the substantive elements of that right are established.
So when you use the word substantive, as you have been doing in this context, you're using it to mean it's a necessary element that has to be established before the right to deduct comes into being.
I am. That's correct, lady. Now, I've mentioned apportionment in the case of residual input tax, and it's Articles 173 and 174 of the Principal Directive that address themselves to that. They're to be found at page 1537 of the joint bundle. So if one looks at paragraph 1 of Article 173, in the case of goods or services used by a taxable person, both for transactions in respect of which VAT is deductible and for transactions in respect of which VAT is not deductible, only such proportion of the VAT as is attributable to the former shall be deductible. So one can only deduct the inputs used for taxable outputs. And it's then provided that the deductible proportion is to be determined in accordance with Articles 174 and 175. In Article 174, at the foot of that page, the deductible proportion shall be made up of a fraction comprising the following amounts, and the numerator and denominator are set out in Article 174. So what one sees then is the directive providing that there has to be an apportionment in the case of this residual input tax category, and Article 174 provides a basis for calculating the applicable proportion. So that's the basis in the directives for the exercise that had to be carried out. And some of the authorities of the Court of Justice helped to elucidate those provisions in my submission. Those cases are discussed in detail in the written case for the Commissioners between paragraphs 40 and 48, between pages 77 and 79 of the electronic bundle. Of those cases, I would like to look specifically at two. Those are number 62 on the list of authorities, which is the case Bundeszentralamt für Steuern, and number 58, Le Credit Lyonnais. I'll look first at Bundeszentralamt, which begins at page 2830 of the joint bundle. The judgment of the court begins there, and paragraphs 1 and 3 identify that the case concerned the right to a refund of VAT which a taxable person incurred in a member state in which it was not established. The facts, so far as relevant for present purposes, can be found, first of all, at page 2833, paragraph 18.
Paragraph?
Paragraph 18 on page 2833. So an Austrian company sought a refund of VAT. Paragraph 19 is explained that in its application for that refund, the numbers referred to as invoice numbers consisted for each not of a sequential number of the invoice, but of another number which was in reference to the invoice as it's put. And paragraphs 7 and 12 of the judgment, paragraphs 7 and 12, identify the requirements of the directive in that respect in relation to the identification of the invoice. Paragraph 20, it's explained that the federal court, the German federal court, rejected the claim for deduction of the inputs as not complying with the formal requirements of the directives. I should mention in this respect at paragraphs 26 to 29 on page 2834 and also paragraph 32 on the same page, there is some discussion of whether the German tax authority bore some of the blame for the nature of the taxpayer's claim, because the German legislation referred only to the provision of a supporting document number and not an invoice number. That was the background to the claim, but so far as the principles are concerned, for present purposes, they are to be found at page 2836, paragraphs 45 to 48. So paragraph 45, the court explains that the right to deduct, just like the right to refund, like the right to deduct, is a fundamental principle of the common system of VAT, intended to relieve the operator entirely of the burden of VAT due or paid in the course of his economic activities. And that ensures fiscal neutrality. Paragraph 46, the right to deduct and accordingly the right to a refund is an integral part of the VAT scheme and in principle may not be limited. The right is exercisable immediately in respect of all taxes charged on input transactions. Paragraph 47, the fundamental principle of VAT neutrality requires the deduction or refund of input VAT to be allowed if the substantive requirements are satisfied, even if the taxable person has failed to comply with some of the formal requirements. Then at paragraph 48, the court says, the position may, however, be different if non-compliance with such formal requirements effectively prevents the production of conclusive evidence that the substantive requirements have been satisfied. And it's important to pause here and note this, that in the ordinary case, the right to deduct is exercised at the time in each tax period by the taxpayer on the submission of a return. And therefore, the question of whether the substantive requirements have been met usually arises after the right has purportedly been exercised, where the tax authority might inquire into the affairs of the taxpayer. This is a different situation, the present appeal, where the right is being sought to be exercised and the question of whether the right exists are being dealt with at the same time long after the right, if it existed, arose. Now, those are the general principles set forth by the court in that case, and for completeness I should mention to the court that as to the particular issue that arose in that case, the failure to use sequential numbers of the invoices, perhaps unsurprisingly, the court held at paragraph 58, to be found at page 2837, that where the application did not contain the reference to the sequential number of the invoice as required by the directive, but did contain a number that allowed the invoices to be identified, the National Tax Authority had to consider the application and to proceed with its assessment. But that it may, and this is paragraphs 57 and 58, it may require the actual invoice numbers to be provided, and if they were not, to reject the claim. But it's the principles at 45 to 48 in my submission that are important. Now, on the basis that the right to deduct is subject to requirements of both substance and form in any given case, one important example of the application of a substantive requirement so far as the right to deduct is concerned is to be found in the second of the two cases I mentioned I would look at, Credit Lyonnais. The judgment of the court in that case begins at page 2757 of the electronic bundle. paragraphs 8 and 9, the court quotes from Articles 17 and 19 of the 6th Directive, which correspond to Articles 173 and 174 of the Principal VAT Directive. Some detail is provided, again, so the court has the reference at paragraph 14 of the court's opinion, or decision rather, at page 2762. The French tax authority had refused to permit Credit Lyonnais to take account of the interest on loans granted by its principal establishment to its branches outside of France in the numerator and denominator of the deductible proportion laid down in French law implementing Articles 173 and 174. Paragraphs 28 to 29, the court highlights that only a proportional deduction is permitted in accordance with the directive. And at paragraph 31, the court explains that it is for member states to determine the method for determination of the right to deduct. Paragraphs 32 to 34 are concerned with the specific issue that arose in that case to do with establishments and branches, an issue that doesn't arise in the present case. But for my purposes, I draw attention to page 2765, paragraph 35 of the judgment of the court. So page 2765, paragraph 35, and the first sentence in my submission, the court affirms the core proposition that I advance in this appeal, that the methods of calculation of the proportion of the deductible amount constitute a fundamental element of the deduction system, as I would have it, a substantive element of the deduction system. So in relation to the EU law, in relation to the right to deduct inputs, where inputs are used partially for taxable activities and partially for non-taxable or non-economic activities, and it's agreed that that's the basis of the claim here, this mixture, deduction is allowed only to the extent that the expenditure is attributable to the taxpayer's economic activity, that apportionment in my submission being a substantive requirement of the directive.
Well, the apportionment's a substantive element, but what we're concerned about here is proving it, aren't we?
Quite so. And in relation to the first thing is that takes me back to the submission I made a short time ago, that it being a substantive element of the right in question, we're not properly in the territory of a mere quantification of a right that exists. It's an integral part of the right itself. And what has to be established for that right to be exercised, and what has to be proved in my submission, is a definite amount of VAT due or paid in respect of inputs.
And you say that has to be proved by the taxpayer?
It does.
Is that emerge from these cases?
I think it's common ground in this appeal anyway that it was for the taxpayer to prove its claim for a right to deduct inputs. The taxpayer is the one who's exercising the right to deduct. It's for the taxpayer to establish that it has that right, and I say that an integral or substantive element of that right is the establishment of a definite amount, and in cases of this sort, the apportionment that supports that definite amount.
I would have thought that was obvious. What we're arguing about is, what the argument is about is what you have to do to prove the definite amount.
Well, it may be obvious, and we would see it as axiomatic of the case that we advance on behalf of the commissioners. But for the reasons that I've touched on already, and which I'll seek to develop in my submission, there is this point of departure between, on the one hand, the approach for which I contend, and on the other, the approach of the taxpayer in the First Division, which treats the right as having been established in the abstract. My submission is the right doesn't exist in the abstract. It's a right to deduct, an actual amount, and in this case it's a right to deduct an actual amount which is dependent upon an apportionment.
I thought, well, I agree it's a bit ambiguous, but I thought the point that was being made was actually a slightly different one, which was that one can be pretty well satisfied here that there was an amount of input VAT capable of being reclaimed. The problem is that they can't identify what it was. Whether that should make any difference, that one can be fairly sure that there was an amount of some amount, may be an open question. But that I thought was the point being made.
Well, my submission is that the distinction is more than just a semantic one. It's because the right arises only in relation to a definite amount of VAT due or paid, in this case apportioned to the taxable activities, that one has to establish those things before the right arises, rather than just a mere difficulty of proof of a right that has already been established. In my submission, there is a fundamental difference in my submission. I was going to turn then to the third part of this particular chapter, the discussion of the law in relation to the right to deduct, to deal with the domestic law in relation to the right to deduct inputs and what are now termed Fleming claims. And I'll deal with four things in relation to that. I'll look first at the UK statutory scheme for accounting for VAT generally and deduction of inputs, taking that very briefly. Secondly, I want to look at the decision of Mr. Justice Neuberger in the case of University of Sussex. Thirdly, look at the House of Lords decision in Fleming. And fourthly, Section 121 of the Finance Act, which is the statutory basis for the present claim. Now, looking at the United Kingdom scheme for the deduction of inputs and indeed for VAT generally, the first thing to note, and we mentioned this in our permission application, paragraph 22, page 19 of the electronic bundle. The House of Lords has observed more than once that VAT is a self-assessed tax, and it's intended to be self-policing, and it's supposed to be a basic strength of the VAT system, that it's supposed to operate automatically on the economic activities of taxpayers, with, as it's put by the House of Lords in Lex, the references at paragraph 22 of the application for permission, as I said, with the least possible need for VAT authorities to undertake independent investigation of the facts. So, in relation to claims for overpaid VAT, those were governed by Section 80 of the Value Added Tax Act, subject to a 6-year limitation period. But, as has been made clear by the House of Lords more than once, Section 80 deals with VAT that was not due, with overpayment of VAT. One example of that would be Lord Walker of Gestingthorpe in Fleming, paragraph 31, page 1658. What we see from the cases is that Section 80 is not the gateway via which unrecovered input tax is claimed. Rather, the gateway for those claims is Regulation 29 of the VAT regulations. Now, prior to the changes that were made to Section 80 and also to Regulation 29 of the VAT regulations in 1996-97, the effect of Regulation 29 has been held by the House of Lords in Fleming to be claims under Regulation 29 to recover input tax could be made without limit of time. So I could give the references to the speech of Lord Scott at page 1652 of the joint bundle, paragraph 20 in Fleming.
Sorry, could you give me that page number again?
Certainly, 1652.
Thank you.
Paragraph 20. On the second line of that paragraph, Lord Scott said, the UK instituted a VAT scheme for the repayment by the Commissioners of Input Tax that enabled claims for repayment to be made without limit of time. That was a surprising and perhaps unintended feature of the scheme, but was a lawful feature. There is no suggestion the scheme failed properly to implement the 6th directive. And in that paragraph, His Lordship then went on to discuss the chronology of events that led to the introduction of the time limit with the absence of transitional provisions. So that view of Regulation 29, that as it originally stood, it was the basis for claims for recovery of input tax, and that it allowed claims to be made going back without limit of time. In that respect, the House of Lords was endorsing the approach which had been taken by Mr Justice Newberger, as he then was in University of Sussex, paragraphs 51 to 52 at page MS 1969. Now, with that mention of Mr Justice Newberger's judgment in the University of Sussex, if I could turn to that now. The report begins at page 1955. There are two fundamental points I would seek to draw out from Mr Justice Newberger's judgment in that case. The first is that a failure to claim input tax does not mean there has been a overpayment of tax. There has not been an overpayment of VAT. And I can give the court two references to that. Paragraph 63 on pages 1971 to 1972. And that passage, I should say, is quoted with approval by Lord Walker in Fleming at paragraph 34 at page 1659. The second point of importance that emerges from Mr Justice Newberger's judgment is that a taxpayer is under no obligation to claim input tax. That can be seen at paragraph 68 of Mr Justice Newberger's judgment, beginning at page 1972. On the final line on that page, His Lordship said, "It is clear from section 26 subsection 1 that the taxpayer's primary right is to claim input tax in respect of supplies for the period to which the return relates, but there is nothing which suggests that if he underclaims input tax, the net amount which he pays is to be treated as VAT, which is not due. On the contrary, by using the word entitled, while giving the taxpayer the right to deduct input tax, does not suggest that he is under an obligation to do so." In other words, in acting as the tax collector for the state, as the taxpayer does, if the taxpayer chooses not to recover his inputs, that is a matter for the taxpayer. I've touched upon one of these points already, but there are two consequential effects of that for the purposes of the present appeal. The first is that, in my submission, it's correct that the taxpayer is not under an obligation to deduct inputs, and that's of some significance in the present appeal, because when one looks at the Inner House opinion, one of the grounds in my submission on which the Inner House attributes state fault or identifies state fault is the suggestion that there was a failure by central government in the period when it was responsible for the VAT affairs of health boards. It was responsible for the failure to recover inputs. And there being no obligation to do so, there cannot be fault in my submission. And the second point is one I've touched on already, that as Mr Justice Newberger, endorsed by the House of Lords, says, if inputs are not deducted, there hasn't been an overpayment of tax, so we're not in the territory of San Giorgio, of tax levied in breach of EU law. as I've mentioned already, the court will see when it looks in detail at the written case for the taxpayer that there is a repeated reference to recovery of overpaid tax, and that infects in large measure in my submission the analysis of the First Division as well. I want to turn within this chapter next to look at the decision of the House of Lords in Fleming, and what is mentioned in the case for the commissioners in relation to this issue so far as state fault is concerned is that it's been put in our case that state fault provides, as it's put, maybe the context to the issues that have arisen in the present appeal, and the taxpayer in this appeal, apparently, but in my submission wrongly, seems to regard that as a significant remark. That's apparent from paragraph 120 of the taxpayer's case at page 128. I'll explain, however, what's meant by the reference to state fault providing context, and one understands that by looking at the decision of the House of Lords in Fleming so far as state fault is concerned. Now, of course, the background to that litigation and to that appeal ultimately was the enactment within the United Kingdom of limitation periods for claims of this sort on terms that did not make provision for a satisfactory transitional period. And if one goes to page 1668 in the speech of Lord Walker of Gestingthorpe.
I'm sorry to interrupt you, but just before we do that, are you going to take us at some point, I should have asked you this when we were looking at the Principal VAT Directive. You took us to 167 and 168. I wonder if you were going to take us to 178 at some stage, dealing with the rules governing the exercise of a right of deduction. I mean, obviously it's a matter for you, but
So 178 introduces a number of conditions, the most notable of which is the possession of an invoice, VAT being a system that is essentially dependent upon the production of invoices. So that is undoubtedly one of the rules set forth in relation to the exercise of the right of deduction. Yeah. However, in my submission, it's ultimately a matter for the national court to decide issues of proof and whether the right has been made good. And in this,
I mean, as you'll know, there's quite a lot of case law in Luxembourg about the sort of what the requirements are in order to establish the amount of your claim. And I presume you'll take us to that at some stage. 178 is a sort of starting point, you know, but it's a condition according to that. In order to exercise the right of deduction, a taxable person must meet the following conditions. A, for the purposes of deductions pursuant to 168A, which is what we're concerned with, I think, he must hold an invoice. I mean, on the face of things, that seems relevant.
Well, in the present case, in the present case, the taxpayer effectively put before the commissioners and the tribunal all of the evidence which it in fact claimed to possess at that time. Mm. And the commissioner's position in relation to that was, and the approach endorsed by the tribunal, was that that material was not sufficient to establish the right to deduct, including the apportionment that had sought to be undertaken. What the Commissioners did not do, though, and what the Tribunal did not do in my submission, is say there is no invoice showing these taxable inputs, therefore no further inquiry is necessary. There was in fact an inquiry and an assessment of the evidence that was adduced, so that in my submission was on any view at least a sufficient analysis of the evidence that was put before it by the Commission, put before the Commissioners by the taxpayer and put before the Tribunal.
So you're not relying on Article 178?
You've never argued that as a matter of law the claim must fail because they can't produce an invoice?
No.
Because there is a discretion on HMRC to accept alternative evidence. And you in fact accepted the blue books as showing fairly accurately.
Yes.
Even despite the lack of invoices, what VAT had in fact been paid, the trouble was how to apportion that between business and non-business activity.
Yes. So Regulation 29, subparagraph 2, allows the Commissioner to make directions in any given case or generally about what will suffice. And in the present case, I will give the Court the references to the correspondence issued by the Commissioners in response to the claim as presented. And rather than requiring the production of specific documents in the nature, for example, of invoices, the consistent position of the Commissioners was to say, you need to prove, you the taxpayer needs to prove that these taxable inputs were incurred, and you need to prove the basis of the apportionment, and please give us more evidence to support that.
And are you going to take us to the Vaden judgment, or indeed the opinion of Advocate General Cocotte?
That's referred to, of course, in our written case, and I rely on what's said there about that.
Because you'll appreciate that one way of approaching the issues here is to say, well, this is all about domestic law of evidence and on applying ordinary principles to do with the burden of proof and the burden of proof, the standard of proof.
Yes.
The taxpayer fails. They just haven't got the evidence to establish their case. Another approach which might be adopted along with that one, or it might not, is to say, well, there are requirements as a matter of EU law as to the quality of the evidence that has to be provided, and those EU requirements have not been met in this case.
That's not the basis on which I present the appeal.
Right.
That on an EU law basis,
yep.
The
that's fine.
nature of the evidence was ruled out in limine, as it were. That's not the approach for which I contend. I will ultimately arrive at the point which was the start of my Lord's question to me, that one analysis is on ordinary domestic law principles in relation to the burden and standard of proof the claim fails, and that the Inner House didn't have a proper basis for interfering with the findings in fact. That's my ultimate position, and an alternative, shorter disposal of the appeal. But
you say, as I understand it, it was for the tribunal to decide whether there was enough evidence to prove the case, and they found there wasn't, and didn't make any error of law, and that's the end of it, in fact.
I do. I do. That they asked and answered the right question. It was for them to evaluate the evidence. They did, and in particular.
And just because the taxpayer hasn't waited 30 years to claim, it doesn't mean you have to bend the law somehow in its favour when it does make a claim.
Correct. And indeed,
not a case where it couldn't have claimed.
Well, indeed, and this is, I'll come on to develop this point. In looking at state fault, the Inner House, in my submission, appears to have arrived at the rather startling conclusion that the United Kingdom singularly failed to implement the EU law right to deduct. In an absolute sense, it seems, until Section 121 of the Finance Act was enacted in 2008. And my submission is that's just not correct. The House of Lords, this is what I'm about to turn to, the House of Lords in Fleming says the only breach of EU law, so far as the UK's implementation was concerned, was the introduction of the time bar, retrospectively, without an adequate transitional provision. That was the breach of EU law. So in the present case, for example, it's clear from the materials that the taxpayer gained control of its own VAT affairs thinking around 1994. So in 1994, it could have submitted a claim to recover input tax going back to 1974. And ultimately, the House of Lords, Mr. and Mrs. Newberger, tell us they could have done so under Regulation 29 without limitation of time.
Well, they could have made claims in 2000, 2001, 2003.
Correct.
Any year, but they didn't. In fact, they're time barred for those claims, as I understand it. But for the claims in 2001, for example. Is that right? They're time barred for claiming back input tax for, say, the year 2001.
Yes.
But it just so happens that there never was a time bar previously, so there's no time limit on them claiming back before 1994 or 7. So that's open to them in principle.
It was.
And still is, if they had the evidence to prove it.
Well, it still is on the basis of the claim that they submitted.
Well, if they'd had enough evidence.
With Section 121.
Yeah.
It's not now possible to do so because of Section 121. A new claim couldn't now be made. But Section 121...
Sorry, it was possible before 2009 to do it, which is what
yes.
they did, 1st of April 2009.
Yes, correct. And the issue is really... the issue is whether they had the evidence to make good that claim. And the first tier, and in common with the commissioners, took the view that there simply wasn't material to make good that claim of the definite amount and the apportionment. And the answer to that, according to the taxpayer and according to the Inner House, appears to be that in cases of this sort, where it's the fault of the state that claims are being made at this time on the basis of inadequate evidence, that somehow mandates a different approach. A generous and flexible approach is how it's described, but a different approach to the evidence. And as the court will have seen, and as I'll mention in due course, one of the curiosities of the analysis of the Inner House is that the Inner House, on the one hand, endorses the judgment of Lord Tyre sitting in the upper tribunal in the first NHS Lothian appeal, in which he says, among other things, the tribunal doesn't operate as a detective, and one of the bases on which the tribunal could refuse a claim is, even if it's satisfied there must be some unrecovered input tax here, but it cannot identify an amount, even a minimum amount, the claim fails. The Inner House says in terms that that is correct, and it endorses that approach, but it then later in the opinion says that a tribunal is not entitled to refuse a claim on the basis of what it describes as difficulties of proof. And those approaches, those findings in my submission are irreconcilable.
It's very important to be clear about what we mean by the fault of the state, isn't it? If it had been the fault of the state in the sense it had been impossible to claim back input tax for those years, that would be one thing. Say it wasn't. The fact it was the fault of the branch of the state which has now come down to NHS Lothian that they didn't claim it, that can't be a reason for assisting them to claim it without proper evidence.
Indeed. Well, there appear to be, in the estimation of the Inner House, there appear to be 3 elements to state fault. One of them is the domestic legislation concerning the right to deduct. And the Inner House, as I've indicated, appears to say that until Section 121 of the 2008 Act was enacted, the UK had basically failed to implement the EU law right to deduct. And I say that's not correct. The second element of state fault identified by the Inner House is that central government was for a long period of time in control of the taxpayers' VAT affairs and didn't make a claim. And I say, well, that's not fault because there was no obligation to do that. There's no obligation to deduct inputs, and indeed it's readily understandable why at that point in time central government took the view that there wasn't much to be gained by one part of central government reclaiming
yes, in those
exactly.
days it was sort of
input VAT.
I might think that today.
Well,
and I remember, and no doubt others can remember the criticism that there used to be when one state agency sued another, and the only issue for the court was which pocket of the state was money going to be transferred from one pocket to another, which is all we're concerned with here. And at one time, the sensible policy, one might have thought, was that the state doesn't litigate over matters that can be settled by budgetary decisions internally. Whereas nowadays, of course, they all fight to defend their own budgets.
Well, that historically appears to have been the position, but that's now, as I read the judgment of the Inner House, that's now cast up as state fault, that the state didn't make a claim.
Well, it's overlooking the fact that the NHS is obviously part of the state itself.
Indeed. And it does also involve a rather peculiar bifurcation, as it were, of the state, that to the extent that the state was in charge of the taxpayers' affairs, surely the taxpayer itself must now bear the responsibility for that. But in the analysis of the Inner House, it doesn't. It's the tax authorities that bear the responsibility for that, or the state more generally. And the third element of state fault identified by the Inner House is the loss of evidence. That's because of state fault, and there's a particular reference to destruction of records by the commissioners. But as I'll show to the court, and I mentioned already, the inquiry was not directed towards issues of state fault. The Inner House, in its opinion, identifies that if there is a loss of evidence, the Inner House says it would be relevant to understand why evidence has been lost, who bears responsibility for it, and what has happened. But the inquiry before the first year was not directed to that, so there are no findings about it. But to the extent that there are findings about the loss of evidence, it's all to do with the taxpayer itself losing things, moving offices, destroying its own records, and so on. And none of it's tied in to the question of whether it could make a claim for deduction of input tax. So there's no finding about what was lost, when it was lost or destroyed, why, on whose decision, and so on. In any event, where I was looking briefly at the House of Lords decision in Fleming. I think I had mentioned paragraph 60 of the speech of Lord Walker at page 1668. That's the reference in particular to that the only breach was the imposition of a new time limit with no transitional period, and the only breach, and that breach was in its nature transient, as is put by Lord Walker. What the House of Lords ultimately held in Fleming was that's the only breach, and that what the principle of effectiveness required was that limitation periods be of a reasonable duration and fixed in advance, and that any curtailment of existing limitation periods must have an adequate transitional period. The House of Lords also endorsed the approach of Mr. Justice Newberger in University of Sussex, that Regulation 29 was the basis for claims for unrecovered input tax, and that such claims were not subject to any time limit until the introduction of the time limits in 1997. So the speech of Lord Scott at paragraph 19 is an example of that. And my reason for looking at Fleming in that respect is to emphasise and place in proper context the allegation of state fault so far as the implementation of a right to deduct is concerned, because we'll see that features prominently in the analysis of the Inner House. The fourth thing to look at in connection with the domestic law on the right to deduct is section 121 of the Finance Act. And I want to just pick up on something that the taxpayer says in its written case about that. So at page 114 of the bundle, paragraph 63, the taxpayer sets out its analysis of section 121. And what it says is, in allowing VAT recovery claims going back to 1973, Parliament must be taken to have appreciated that such claims could not be dismissed or constrained because ordinary evidential requirements could not be satisfied. There is a dynamic relationship between the nature of the claim which Parliament allows NHS Lothian to make and the evidential requirements which the board must satisfy to make good its claim. And then at paragraph 64, there's an analysis by the taxpayer of the scheme established by section 121 to confer the right to repayment claims going back 24 years. Parliament must be taken to have intended overpaid tax, posing there, this is not an overpaid tax claim, but overpaid tax should be recoverable even though the normal documentary evidence required for tax claims would not have been preserved or available because of the inherent nature of a historic claim. Parliament must have intended the claim to be based on notional figures, assumptions, extrapolation, interpolation. Parliament must have intended a broad brush approach should be taken. Now, my submission is that first and fundamentally, section 121 says nothing about the evidence that will be required for the purposes of a claim made thereunder, except to this extent. And if we look at section 121, which is at page 1464 of the joint bundle. So subsection 2, this is the one that we're concerned with specifically about claims for deduction of input tax. It may be made at such time as may be determined by or under regulations that does not apply to a claim for deduction that became chargeable and in respect of which the claimant held the required evidence. And I'm going to come back to that. In a prescribed accounting period ending before 1st May 1997 if the claim is made before 1st April 2009. That was the provision that was put in place. But the phrase, and in respect of which the claimant held the required evidence, the required evidence is said to be the evidence of the charge to value-added tax specified in or under Regulation 29.2 of the VAT regulations. That's to be found at page 1446. And Regulation 29.2, at the time of claiming deduction of input tax in accordance with paragraph 1 above, the person shall, if the claim is in respect of a supply from another taxable person, hold the document which is required to be produced under Regulation 13. And that, to pick up on my Lord and the Chair's questions to me earlier about invoices, that takes one back to production of invoices. So Section 121 in terms introduces a condition that the taxpayer has to have held the required evidence, as I would read it, at the time the claim arose. So at the accounting period in question, when the deductible input arose, the taxpayer has to have held the required evidence.
But in any event, all that Section 121 does is say that you can't introduce a time limit retrospectively.
Correct.
The fact there's no time limit doesn't mean that if you choose to wait 30 years to make your claim, the law has to lower the ordinary standards of proof.
Well, I concur, and I say that that's really for two reasons. One, there's not a word about that in Section 121, and if Parliament had intended to introduce some different standard, it would have said so, if it was innovating upon basic principles of the law in that respect. The second is, and contrary to the analysis offered by the taxpayer, that Parliament must have intended this very generous approach to proof of these claims. Well, the history of the legislation would rather tend to suggest otherwise, that as the taxpayer makes clear in its case, the commissioners were resisting these types of claims all the way. And there was a legislative desire to avoid claims of this sort being made, and Section 121 was enacted in order to respond to the decision of the House of Lords in Fleming. So any suggestion that it was a desire to open the floodgates to claims where the documents didn't exist to prove them, in my submission, is unsound.
I thought you were making a point rather that insofar as Section 121, subsection 2, says anything about the way in which you establish your old claim, it seems to be saying you have to do it in the way that you would have done it at the time.
Well, what I was suggesting, my lady, is that the extension of the time limit for the claims under Section 121, in my submission, appears to be subject to a condition, and that condition is that in respect of which the claimant held the required evidence. Held, not holds, held.
Oh, okay.
So the parliamentary language appears to be, in my submission, that it has to be shown that the taxpayer did have the required evidence in the accounting periods within which the right to deduct arose. Now that would mean, to go back to the facts of the present case and the evidence such as it was about the loss of evidence, in order to avail itself of Section 121, the taxpayer would have had to show that it did possess all the relevant documents that were required for a valid deduction claim at the time the right to deduct arose in each period of time over the Fleming claim period. But it no longer has that documentation. But there are no findings in fact about that. There are general findings about...
Well, one might assume, given the content of the blue books, that they must have held the supply invoices from the suppliers of the goods or services on which the input tax was paid. But what there wasn't any evidence of was that anyone at the time had kept any records as to, well, this hour I've spent doing a swimming pool water test for the local authority, and now this afternoon I'm moving to do something for Ward X at the hospital. There was no evidence that they'd ever kept records as to the apportionment of their time between business and non-business activities. Is that right?
It's correct to some extent, although I would add that the required evidence takes one back to the requirement for invoices. So there would, in my submission...
I thought we've got past that by saying that, in fact, although invoices are required, there is a discretion which seems to have been exercised in this case by HMRC to accept other evidence.
The Commissioner certainly looked at all the material that was presented to them, and so did the tribunal. Really, what I'm offering to the tribunal, to the court at this stage, is a submission about the proper construction of Section 121, and I'm offering the submission that it does appear actually to be subject to a condition that the time limit is only extended if the required evidence was held at the time. And there are no findings about that, for what that's worth. Now, to pick up on the issue which my lady, Lady Rose, has just raised with me, I said I would give the court references to the correspondence issued by the commissioners asking for evidence, which, to the extent that there was any direction under Regulation 29.2 asking for evidence, it's to be found in a series of letters. So there's a letter of the 22nd of December 2009 at page 355.
I'm sorry, I didn't catch the number.
A letter from the Commissioners dated the 22nd of December 2009.
Yes.
Page 355.
Thank you.
That letter indicates that the Commissioners are saying to the taxpayer it's for it to demonstrate that input tax being claimed was incurred in the course and furtherance of taxable activities, and that they were entitled to deduct it, and no evidence of taxable income from the laboratory supplies had been provided, that no evidence had been provided in relation to the input tax being claimed, and effectively culminating in a request for further supporting evidence. And that message of we don't think you've given us enough, please give us more, because you have to prove your claim, is repeated in letters dated the 22nd of September 2010 at page 357, the 18th of November 2010, page 371, the 23rd of December 2010 at page 388, and the 14th of November 2011, which is the review letter at page 833.
838.
833, sorry.
833.
33, yes. So in other words, it's correct that this is not a case where the commissioners required the taxpayer to produce specific types of documents, such as specifically invoices. The commissioners just kept saying, you need to vouch and support your claim, give us more. We don't think you've done that. And that was the ultimate basis.
But did they focus on the apportionment as being the particular problem?
It would be fair to say that's the central concern that's identified, yes. So,
if they produced evidence of their turnover and showed which part of the turnover was taxable and related to taxable work and which non-taxable, then it would have been an acceptable method, would it, to use that proportion and apply that to the inputs?
Well, that's essentially the fraction identified by Article 174.
Yeah, exactly. So you don't have to analyse each cost that you've incurred and say what that particularly related to. You can take all your costs as a lump sum and apportion them pro rata to your turnover. Is that right? That's a permissible method. So the problem here was that they couldn't identify the turnover and hence apportion that between taxable and non-taxable.
Yes. So the broad measure, yes, Lord. So the approach which the taxpayer took to the quantification of its claim was to use that numerator and denominator fraction for 2006-7.
Yeah.
And that identified,
because they couldn't prove what the turnover had been in earlier years.
correct. And then they sought to, as they put it, extrapolate that back to the Fleming claim period. And in that respect, the first-tier tribunal makes certain findings that during the claim period, in other words, during the period 1974 to 1997, there hadn't been a material change in the nature of the supplies and an inference that the nature of the inputs would have remained broadly the same in the Fleming claim period. And the Inner House then uses that as a basis for criticising the first tier and saying, well, that means, in light of that finding, what was wrong with the extrapolation? And the short answer to that, and we're back to general principles of appellate jurisdiction, the short answer to that is, in order to use the 2006-7 calculation for the period 1974 to 1997, there would have had to be findings that that was an appropriate comparison, that there hadn't been a change in that period from 1994 to 97 to 2006. And there's no findings about that.
Was the 14.7% used in 2006, 2007, was that a fraction of the income that had been earned or the sort of work that had been done?
I thought it was the income as a proportion between the taxable and non-taxable, and then applied to the expenditure or the inputs.
Yes. I'll see if I can bring up the relevant details.
It would be helpful, at least for me. Obviously, we've all read this, but if you could remind me, in the 14.7 was a proportion of something. We're not sure at the moment if it's turnover or income, but a proportion of taxable as against non-taxable or business as against non-business activities. Did you then have a figure for the Fleming years for the total input tax to which you could then apply that proportion on the assumption that the input tax was incurred to the same extent in respect of taxable as non-taxable activities?
So my direct answer to that would be there's no finding in fact about that.
Well, what do you do with the 14.7%, even if it were accepted?
So what the taxpayer sought to do with it is to use the blue books, which recorded expenditure, and to apply the percentage to that information, subject to certain other calculations.
I see.
But the first year itself didn't make an actual finding in fact about what the total inputs were.
That's total expenditure. So you assume that the expenditure is incurred equally in respect of taxable and non-taxable outputs, and you also, I suppose you're then treating whatever the appropriate rate was, 20% or whatever it was, of the total expenditure as having been input tax.
That would be the part of the essential logic of the taxpayer's calculation. That there were...
Well, it was accepted for 2006, was it?
Correct. There were certain further complications about that whole exercise because, for example, the court may have seen some reference to a dispute about direct attribution.
Yes.
So the Commissioner's position was that to the extent that an input is wholly ascribable to a taxable activity, it's a recoverable input and it should be taken out. And to the extent that an input was related to non-economic, non-taxable activity, it should be taken out, and one should only be applying this apportionment to the residual input tax that's left. Yeah. That was the Commissioner's position, and it was the subject of some dispute before the tribunal about that. But what the first year didn't make is a finding in fact. Here is the figure of residual input tax to which this proportion would be applied.
Well, was there a finding that the blue books, or did HMRC accept that the blue books did give you a figure for the input tax which had been paid during the years covered by the blue books, even though it would of course have to be adjusted first to split out, as you say, directly attributable inputs, and then the percentage split between business activity and non-business activity would be applied to that. But as I understood the respondent's case, they say that they had got over that hurdle effectively.
So it wasn't agreed. What the first tier... so page MS 221, paragraph 193.
I'm sorry, what page?
So page 221 of the electronic bundle, paragraph 193. What the tribunal says about the blue books, this is on line 17, the blue books do not record income except for that arising from catering. Such other accounting information as is available is insufficient to show each element of sectorised income of each health board.
But that's focusing on the income. It's not saying they didn't prove the expenditure.
Yeah,
Yes, this is leading up to the conclusion that there's been a failure to prove what the output tax was.
Page 222, paragraph 199, line 20. The blue books have value as prime records, but they show essentially the level of expenditure with a coded breakdown. The witness evidence, while we accept it, speaks only very generally to the types and level of business activity.
I'm sorry, I'm having trouble hearing you, obviously. I thought you'd said paragraph 119.
199.
199, right.
On page 222.
Right. Thank you.
Well, I would find it useful to know what HMRC accepts or accepted. The blue books did show how many, if any, hurdles it's accepted that the blue books got over. You don't have to answer now.
I'll
think about.
I'll reflect on that, but the finding made by the tribunal about this issue of expenditure, such as it is what we see in paragraph 199. That the blue books have value as prime records. They show the level of expenditure.
Maybe they didn't say specifically one way or the other whether the expenditure was proved, but what they identified the flaw as being was that the income couldn't be proved, and therefore you couldn't carry out an apportionment.
Yes.
Am I right in thinking that the first-tier tribunal essentially identifies two problems with the claim? Paragraph 193, they say that they're not satisfied that they've got good evidence of what the output tax was in respect of the business income. And then 196, they say they're not prepared, they don't accept the inferences that they were invited to make on the extrapolation back basis.
Correct. So I would submit, my Lord, that the key part of the tribunal's reasoning for its rejection of the appeal is to be found in paragraphs 194 to 196. And it contains those two elements which my Lord Sales has just identified. And so far as this...
And I'm so sorry, why do you start at 194? Because 193, they...
I meant to say 193.
Oh, okay, fine.
So 193 to 196. And so far as the second point is concerned, the refusal to accept the reasonableness of the apportionment, the tribunal gave a number of reasons for that, one of which I touched on a moment ago, which was that one simply couldn't rely upon the soundness of the extrapolation exercise, even on the findings the tribunal made, so far as the claim period was concerned.
And I think the tribunal is making the point that both these elements affect the claim, because in 195 they say this shades into the final and major consideration.
Yes.
So it's the 2 points taken together.
It is. And
with them.
And some points that flow from that in my submission are these. To the extent that the inner house ultimately and effectively construed the first-tier judgment as meaning that it was looking for certainty, or it was only going to find in favour of the taxpayer if the primary documentation had been produced. Had that been the ground of decision of the first-tier tribunal, they would not have gone through the exercise that one sees in paragraphs 193 to 196. They would simply have said the documentation has not been produced, the claim fails. But they explain why the methodology adopted by the taxpayer has been considered but can't be accepted. And it follows from that I would suggest to the court that what follows from paragraphs 197 onwards is effectively largely obiter. That's the tribunal saying, here's the kind of thing that you might need to make good a claim of this sort, that you might need to support the reasonableness of an extrapolation exercise. But it has considered the evidence put before it on its own terms and for what it was worth. So I had been dealing with section 121 and submitting that it doesn't bear the weight that the taxpayer seeks to put on it as this opening of the gates to claims on the basis of inadequate evidence. Can turn then to the chapter concerning the principle of effectiveness, and I think I can take this reasonably short on the basis of some of the discussion that has been had already. So it's common ground between the parties to this appeal that the principle of effectiveness prohibits domestic law from imposing what might be characterised as onerous collateral conditions or disproportionate procedural requirements for the enforcement of EU law rights. And I'm there quoting the words of Lord Sumption in FII paragraph 146, which is to be found at page MS 1739. Quoted in the Commissioner's case at paragraph 62 on page 82. The leading case, of course, in relation to this is San Giorgio, and for present purposes one can probably turn directly to paragraph 14 of the judgment of the Court of Justice at page MS 2328.
Sorry, could you give that number again?
So paragraph 14,
Got that.
page MS 2328.
Thank you.
Now, in that paragraph, there are three critical points identified: that any requirement of proof which has the effect of making it virtually impossible or excessively difficult to secure the repayment of charges levied contrary to community law would be incompatible with community law. That is particularly so, secondly, in the cases of presumptions or rules of evidence intended to place upon the taxpayer the burden of establishing that the charges unduly paid have not been passed on to other persons, or of special limitations concerning the form of the evidence to be adduced. And then finally in that paragraph, once it is established that the levying of the charge is incompatible with community law, the court must be free to decide whether or not the burden of the charge has been passed on wholly or in part to other persons. So, looking at the present case, my submission is there's no requirement of proof as a matter of domestic law which has made it impossible or excessively difficult for the taxpayer to prove its claim. We're not here dealing with any case involving the imposition of presumptions, such as was at issue in San Giorgio. And indeed, if anything, what the court in San Giorgio says is the court must be free to decide the issues in question. And in my submission, that is exactly what was allowed for and provided for in domestic law.
It must be part and parcel, though, of the obligation to remedy the breach of EU law there had been in imposing the deadline without without sufficient transitional provisions, that in enacting section 121 to make good that, they didn't give with one hand and take away with the other by, for example, insisting that you had to have every invoice going back from the over decades, or imposing some other procedural requirement.
So there were no additional procedural requirements introduced or imposed, or evidential requirements on such claims?
There must be some room for the principle of effectiveness.
Indeed, the second point I would make in responsibility is that the breach in question, one has to remember, was characterised by the House of Lords as a transient breach. So it wasn't this long-standing breach as analysed by the Inner House. It was the transient breach that arose from the introduction of a time bar without a transitional provision. So there was always the ability to make this claim before 1996-97. And that, in my submission, is a matter of significance. And then ultimately, in the event, to the extent that the commissioners had a discretion to consider material beyond the paradigm of invoices and the like, they did so.
Yeah, so the people who might have suffered, the taxpayers who were at risk of suffering as a consequence of the introduction of a time bar without any transitional provisions were people who were in a position to prove their claim.
Quite so. The other point to make, of course, and I've mentioned it already about San Giorgio itself specifically, is although the principle of effectiveness is a broad principle of EU law, the particular context there is charges levied in breach of EU law, which this case is not. So, looking at the application of the principle of effectiveness to the present case, my submission is that the requirement upon the respondent to demonstrate the extent to which inputs were used for taxable economic activity, as we've seen already, that's a requirement of the Principal VAT Directive. It's a substantive requirement of the exercise of the EU law right. It's not an additional requirement being imposed by national law. And it follows, in my submission, that a number of the propositions advanced by the taxpayer are unsound. So, at paragraph 100 of the taxpayer's case, on page 122, it's argued that in requiring evidence of total sales figures for the period in respect of which repayment was sought, the first tier somehow misunderstood the balance of probabilities test. In my submission, it did not. It was applying an appropriate approach to the evidence required to discharge or to establish the substantive right to deduct. Paragraph 103 on page 122 still, the taxpayer asserts that national rules of procedure and evidence cannot defeat an historic VAT claim unless the impact of the rules is justified as proportionate. And again, the only rules that were being applied here, so far as evidential requirements were concerned, was that the taxpayer had the burden of proof on the balance of probabilities and that it sought to discharge that by all available evidence.
And I think you say that that was accepted by the Inner House, that because they endorsed that part of the previous judgment of Lord Tyre.
Yes. Yes. And then finally, or the next point that's made by the taxpayer at paragraph 108 on page 124, there's a reference to what it characterises as increasingly onerous domestic procedural requirements being attached to the making of such a claim. And as I've said already, the respondents have never identified any national rule of law, procedure or evidence that is in that respect said to contravene the principle of effectiveness or to which any proportionality exercise might be applied.
It would have been perfectly consistent with EU laws, I understand, if there had always been a 3-year time limit.
Correct. Absolutely correct. And it's
so to the extent that there wasn't, I mean, they were fortunate.
So yes, absolutely.
It doesn't entitle them to any special relaxation of the ordinary rules of evidence, just because they've got a more generous time limit.
So, for example, in University of Sussex, Mr. Justice Newberger expressly rejected the argument that there was an enduring right as a matter of EU law to claim deductions of inputs. That was rather found to be a peculiarity, as Lord Walker put it, an unusual and perhaps unintended feature of the UK scheme, that claims could be made without limit of time, but that's not an EU law right. Now, I mentioned that in paragraph 14 of San Giorgio, one of the issues highlighted by the court is that the domestic court must be free to decide the issue in question. In other words, it must be free to decide it on the evidence before it. And in that respect, it's worth referring to the judgment of the Court of Justice in a case that I know has been cited to this court recently, doubtless on more than one occasion the case of Sanofi Pasteur. Now, that case between paragraphs 34 and 38 at page 2791 to 2792. The court discusses the particular use of presumptions and their inconsistency or their potential for inconsistency with the principle of effectiveness. But of course, this is not a case. The present case is not a case where any such presumptions were being applied by domestic law. Now, I may require to come back to Sanofi Pasteur, as I'm afraid my tablet has had something of a breakdown and I'm restarting it, so I can't take the court to the electronic bundle at the moment, but I may come...
Well, obviously you're going to have a problem working without access to the electronic bundle. I don't know, either Mr. Richardson let you have his perhaps, or we can adjourn for 5 minutes, or you...
I wonder if I might just have 5 minutes more
yes,
to get the IT working. I'm obliged.
I'm sorry, Mr. Anderson. You look rather like Martin Richardson. So. It does strike us, Mr. Thompson, having had a chance to discuss it, that we're making rather slow progress. You've still got quite a long way to go. So if you're able to speed up a bit, that would be appreciated.
As it happens, I had just been reflecting to Mr. Anderson that I hoped I would be finished earlier than I had anticipated,
Yes,
because the issues I have still to cover, I'm planning to take in relatively short order. I'm grateful, however, for the break. My tablet is working. I had thought there was more chance of myself falling foul of the rigours of the appeal before the technology did, but it's now working. If I could take, my lords and lady, then to Sanofi Pasteur, just to certain of the key passages within it, which are, in my submission, of some significance. So beginning at page 2791 of the bundle. Paragraph 30, in connection with that particular product liability case that came before the French courts en route to the Court of Justice. On the third line, the court mentions the evidentiary rules that rule out any recourse to circumstantial methods and provide that in order to meet the burden of proof, in that case provided for by a particular directive.
Sorry, which paragraph are you in?
So paragraph 30 on page 2791. So evidentiary rules that rule out any recourse to circumstantial methods and provide a particular means of proof, disregard the substantive requirements arising from the directive.
I mean, essentially what they're saying here is that you can't have rules which arbitrarily cut down the evidence which is logically, potentially logically probative of the causation that was the relevant feature in the case.
Correct, and that's what's explained by the Court of Justice in paragraphs 34 to 38, and the particular problem that can arise with presumptions in that respect. And my short point is, that's not this case. All the evidence was admitted, all of it was considered and looked at by both the commissioners and the tribunal. Indeed, as it's put, and as my Lord Sales has just put it, paragraph 38, national courts must allow proof through all means of proof generally allowed under national law. I say, however, that the weight, effectively, of the inner house approach is to require the tribunal here to find a sum greater than zero due to the taxpayer. That arises from the remark that it's not enough to refuse the appeal because of difficulties of proof, as the court puts it. And if anything, that would run counter to the principle of effectiveness as elucidated in a case such as Sanofi Pasteur. So that was all I wanted to say about the principle of effectiveness, and it really comes to this in my submission, that important principle of EU law though it is, and although it has been productive of much jurisprudence, its application in the present case really does not achieve anything of substance, because no rule of national law has in any sense been identified that offends against that principle. And turn then to my third chapter, which is about the role of the tribunal, and I have to some extent touched on this already with references to Lord Tyner's approach in the upper tribunal, the tribunal not operating as a detective and the ways in which a case might fail. So the starting point is, of course, it's common ground that the usual civil standard of proof applies. These types of claims are not actually damages claims, and nor are they in the nature of damages claims, where the court has to assess, by reference to the principles for assessment of damages, what a loss might be or the like. It's a definite sum of money deducted by way of inputs. And of course, my submission is the tribunal did not have an inquisitorial role. It was dealing with the proceedings before it on an adversarial basis.
I don't understand the inquisitorial role point, because it isn't suggested that the tribunal should have come up with some solution other than the one proposed by the taxpayer themselves.
Well, in my submission again, Lord, that's correct. And the criticism of the tribunal...
I thought the real criticism was they didn't accept the respondent's case.
And there's really no basis in my submission for saying that the tribunal considers itself constrained to accept that particular calculation or nothing. Rather, the tribunal considered the claim before it and said that the burden of proof was not discharged. It follows from that the characterisation advanced by the taxpayer and to some extent by the inner house. So, for example, at paragraph 100 of the taxpayer's case, on page 100 MS, the suggestion is that the tribunal effectively required certainty in order to make good the claim. And in my submission, that is not a correct or fair reading of the judgment of the first tier.
Well, that arises because they mischaracterised, arguably, the findings of fact that they had by leaving out the keyword nature from the finding that the nature of the business activity had not changed over time, or the nature of the kinds of testing that they did not change over time, which is what was the actual finding of the FTT.
Yes. Yes. So on a fair and proper reading of the FTT in my submission.
Well, they expressly said that, for example, if they'd been able to prove the apportionment every 5 years, they might have been prepared to extrapolate in between.
Indeed. In relation to the proper approach of the tribunal in cases of this sort, I can take that shortly by giving the court the references to the authorities upon which I rely, and they are first the previous upper tribunal appeal between these parties, which is to be found at page MS 2076, and it's paragraph 19 of Lord Tyer's opinion at page 2083 to 2084, and that's the tribunal not operating as a detective and the ways in which a claim can fail, including where the tribunal thinks that there must be unrecovered input tax, but it just can't find a definite sum. My submission is that that approach is correct. The same approach was taken in another Scottish Upper Tribunal appeal, this time an opinion of Lord Docherty. That was an appeal at the instance of NHS Greater Glasgow. It's to be found at page 2219. And Lord Docherty essentially followed the approach of Lord Tyer in NHS Lothian. And the third and final case is the one founded upon by both the taxpayer in this appeal and also by the inner house to some extent, which is General Motors. And I, for my part, would draw the court's attention to paragraph 68 at page 2101 of the joint bundle. This was the upper tribunal chaired by Mr. Justice Henderson. And at paragraph 68, the upper tribunal makes plain that the first tier was not constrained to accept or reject the taxpayer's approach in that case. Paragraph 69 was a reference to Lord Justice Carnwath, as he then was in Pegasus Birds. This is the dictum that the tribunal, this is between letters C and D, paragraph 69. The tribunal should remember that its primary task is to find the correct amount of tax, and I'll come back to that observation in a moment. But at paragraph 71, and this is really the effective answer in my submission to this issue, Paragraph 71, the upper tribunal says, this is not to say, however, the tribunal is bound to find a way, if it can, of upholding a claim where the quality of the evidence before it is insufficient to justify reaching any conclusion in the claimant's favour, and the upper tribunal there effectively endorses Lord Tyre in NHS Lothian. So to the extent that the taxpayer appears to contend that there was some obligation on the tribunal in this case to search around and find a basis for the claim and quantify it, in my submission, that argument is unsound. I mentioned the dictum of Lord Justice Carnwath in Pegasus Birds, and I just wanted to give the court this reference. At page, there's a case of Volkswagen Financial Services and the Commissioners, page 1842 in the bundle. At paragraph 6 to 7, Lord Carnwath addresses his own previous remarks in Pegasus Birds, and around at letter E, towards the end of paragraph 7, my comments in Pegasus Birds should not be taken as indicating anything different. They were not of general application, but intended, as certain words made clear, to discourage undue attention to the Commissioner's original exercise of best judgment. The traditional approach of the tribunal, the adversarial approach, remains applicable. And ultimately, as I think Lord Leggett remarked a moment ago, the criticism here really of the tribunal is it didn't accept the taxpayer's methodology, not that there was some alternative that it could and should have gone off to find on its own. Turn then to the fourth of my chapters, which is state fault. My submission to the court, as I've mentioned already, is that there was no proper basis for it to be found to have any relevance to the present appeal. My submission is that the Inner House's treatment of that issue is wrong in law for these reasons. As I touched upon in my introduction, there is no factual basis in my submission for a case based on state fault. And I'll take the court to the passages within the opinion of the Inner House in my final chapter when I look at the opinion of the Inner House. I draw attention at this stage to these issues. The issue was not raised or argued before the first tier or upper tribunal. Had it been so raised, the evidence would have been directed towards it, findings in fact would have been made. But in the event there are no such findings.
What sort of evidence would you have had?
Well, the evidence would have to identify, so for example, definite conscious conduct of the taxpayer induced as a result of conduct by the state that has now been seen to be a breach of community law, which results, for example, in the loss or destruction of evidence that would have supported the claim. So in the Inner House, for example, the First Division in its opinion, when it talks about the non-availability of evidence, it says it would be necessary to understand what evidence has been lost and why it's been lost, what the explanation for it is, and whether the taxpayer bears any responsibility for that. And my submission, of course, is that that whole exercise was not gone through before the first tier. And to the extent that there are findings about it in the first tier, they're just indicative of the taxpayer having mislaid its own records. The next point about state fault I've touched upon already, which is no obligation to claim to deduct input tax, and therefore a decision by central government not to deduct at the relevant time is not state fault. The Court of Session in our House, at paragraph 18 of its opinion, asserted that the respondent's failure to recover input tax on laboratory activities before 2006 resulted from a number of factors, including the failure of the UK to implement systematically the EU legislation on the recovery of input tax. My answer to that, as I've indicated already, is that's not correct. The sole breach was the absence of adequate transitional provisions. So, if one steps away from the rhetoric or the hyperbole and seeks to identify what the state fault actually is supposed to be here, in my submission, one will find that there is no proper basis for it, either in relation to the legislative history and certainly not in relation to the facts as found by the first-tier tribunal. The taxpayer, in developing its state fault arguments, appears to place reliance upon the well-known Court of Justice case of Frankovich, the basis for a claim for damages against a state for a failure to implement EU obligations into domestic law. The short point here is this is not a Frankovich claim for damages. There is, in any event, the questionable basis or the limited and transient basis for an allegation of state fault so far as the transitional provisions were concerned. But there's really no attempt to explain how the Frankovich analysis assists in understanding the approach of the tribunals in the present case, or indeed the justification identified by the Inner House for its disposal. So for those reasons, in my submission, in trying to understand what the state fault case is that the taxpayer was making belatedly before the Inner House for the first time, there is a real difficulty in my submission. That then takes me on to the fifth and final chapter of my submissions, and I'm hoping that my suggestion of a few moments ago that I've sped up and therefore will shortly be ahead of schedule are about to be made good. In the fifth chapter, looking at the findings made by the first tier and the errors of law that I say the Inner House made, one has to remember that the first tier tribunal proceedings appeal was an evidential hearing that extended over about 11 days. So on ordinary principles, there was a fact finder, the first tier, that heard evidence over a long period of time and made the findings which it did. I would also observe that so far as criticisms of the judgment of the first tier are made by the Inner House, the court is very familiar with and has recently and often remarked upon the inappropriateness of an unduly harsh or hostile interpretation being adopted so far as the decisions of triers of fact are concerned. And there's a real flavour of that in my submission in the Inner House opinion so far as it seeks to identify errors of law in the opinion or the judgment of the first tier. But a particular feature of the first tier's decision, it must be remembered, is that the legal chairman of the first tier tribunal, Mr. Muir, sadly died after the hearing and before the judgment was published, and it was therefore the non-legal member who had to write the judgment, and Mr. Shepherd says that in terms at paragraph 1. Now, against that background then, the appeal to the Inner House, of course, was under section 13 of the 2007 Act, an appeal on a point of law. The grounds of appeal on a point of law are well known. One takes the summary provided by the Inner House in Advocate General against Murray Group, paragraphs 41 to 43, MS 1918 to 1919. I would also mention in this connection Lord Sumption's remarks at paragraph 35 of the Commissioners and Pendragon at page 1833, in which his lordship said that appeals of that sort are circumscribed by the ordinary principles applicable to any exercise of appellate jurisdiction. One of these is that unless vitiated by some error of principle, a decision based on the evaluation of competing factors will generally be respected. Of course, I say that's exactly what the first tier was doing when it looked at all the evidence that was available to decide whether the apportionment in question was one that could be accepted. Now, I've touched upon the unsound basis of the state fault line of argument already, but I just want to draw certain features of the first tier judgment to the court's attention at this stage, relating first of all to the findings made by the first tier about the unavailability of evidence and also the failure on the part of the respondent to seek to deduct input tax during the periods in question, but also, secondly, more generally, just to look at the reasons given by the first tier. So looking at the question of the loss of evidence, and I'll give the court these references really rather than going through them in detail. Paragraph 19 of the judgment of the first tier at page 188. This is in connection with the evidence of a Mr. Wright, who was a accountancy employee of NHS Lothian. He makes a reference to the financial arrangements of the health board. Much paperwork will now have been destroyed, is noted in that paragraph. Paragraph 20, on the same page, Mr. Wright again, there's a reference to the prime accounts. The receipts would be recorded distinctly, but he explained further that while there were detailed records for expenditure, there were none for income. The evidence of Miss Howard, another finance or accounting witness on behalf of NHS Lothian, at paragraph 25 on page MS 189.
Was there any evidence that the labs had actually charged anyone for the non-business activity, presumably?
No, don't believe so.
There was no sort of hard charging of the services of the labs to other NHS bodies?
No, I don't believe so, my lady. So paragraph 25, Miss Howard, it's what's recorded is she explained that when she was involved in tidying up physically the appellant's financial records, she realised that a lot of documentation had been confidentially destroyed without reference to her. A folder containing one VAT return from the first quarter of 1995 had been given to Mr. Muir of Liaison, the advisors latterly of the respondent. So there's no explanation in that evidence and the findings made about it. What records there were, what was destroyed, when, by whom or why. Paragraph 69 on page MS 197. This is the evidence of a Mr. Lee of Liaison who had interrogated some of the financial records available. His evidence is recorded. There was an acknowledged difficulty in tracing documentary evidence. The health boards had moved offices, there had been a reorganisation and old records had been destroyed. And then finally, the tribunal itself at paragraph 196 on page MS 222.
So I'm just reading on. So the blue books being referred to show consolidated costs of the entire NHS in Scotland.
Yes, and I think there were specific aspects of those books that related to this particular health board.
All right.
I'm afraid I've missed your last page reference.
Yes.
Paragraph 196 at page...
Sorry, my lord, at page MS 222.
222.
222.
Thank you.
And that's where the tribunal, somewhat inconsistently with the evidence of Miss Howard that I just took the court to, the tribunal says the tribunal learned that Miss Howard had innocently had records destroyed except for one VAT return, which she delivered to Miss Muir. Of course, at paragraph 25, Miss Howard is recorded as having saying that she found out that documentation had been destroyed. But in any event, my submission is that the findings, in fact, actually made by the first-tier tribunal really amount to no more than a finding that the taxpayer itself lost and or destroyed its own records. But there are no findings about what records it originally had, whether those records would ever have been good enough to make good a claim for deduction of input tax. Far less is there a finding about what was destroyed, when, by whom, or for what reason. The other issue of state fault, which is raised by the Inner House about the loss of documentary evidence, relates to the destruction of records by the commissioners themselves. And I should mention to the court that this is addressed, it's page MS 170, paragraph 56. So the opinion of the First Division, paragraph 56, it appears from a letter sent by HMRC to the taxpayers' representatives on 21st April 2015 that records held by HMRC for the period before 1997 were destroyed. In 2010, all documents older than 6 years were disposed of. And then this, and the sentence that follows immediately after that is, thus, the state has to bear a major degree of responsibility for the absence of accounting records. In the foregoing circumstances, the failure of the taxpayer to produce sales ledgers or copy tax invoices cannot be considered significant, as the first-tier tribunal appears to have thought. Now, the letter that the court is referring to there is at MS page 835. And I don't intend to go to it in detail, just to give the court the reference. But what the court will see in the letters in question at that part of the bundle is the taxpayers' representatives asking HMRC to produce certain approvals and a response by the commissioners that they don't have the documents that are being asked for. And there are no findings, of course, by the first tier about this, the significance of it, what records were destroyed by the commissioners and so on. But the correspondence, such as it is just the commissioners being asked to produce certain records and the commissioners saying they don't have the records. And the difficulty in my submission, so far as the analysis of the inner house is concerned, is that limited material doesn't provide any weight for the inner house's conclusion that material records were destroyed by the commissioners.
And that, you think at paragraph 56, that's what they were referring to?
Well, in my submission, that appears to be the reading of it, that there's really very little reference in the inner house's opinion to the loss of records by the taxpayer, and what's focused upon is the commissioner's destruction of records. And as I say, 4 lines into paragraph 56, immediately after referring to the destruction of records by HMRC, it's thus the state bears a major degree of responsibility.
The letter, the heading of the letter is request for HMRC VAT approvals. And the writer is responding, it seems, to a request relating to handwritten records in the London team office for approval before 1997. So these are internal revenue records by the look of things.
Yeah. And
the writer is telling us that the NHS team was only formed in 1994, so there simply are no records at all before that date. So in other words, they wouldn't have had any, well, we'll see what it says. And he's saying that after that date, until 2010, all the records that he's referring to were kept manually, and then in 2010 it was put onto computer records, and the manual records were destroyed. So, right. Right. Okay.
Just out of interest, do we have the bundle reference for the letter of the 9th of April 2015 to which this is a response?
Yes. While I track that down, what I would observe about this correspondence, and the focus is, as my Lord and the Chair has indicated, upon the records of the commissioners. So let's remember, VAT is a self-assessed tax. The records are going to be held by the taxpayer in relation to its VAT account and so on. Without more, one would not prima facie expect the commissioners to be in possession of the records required to make good the claim for deduction to input tax. One would not expect the commissioners to have that material. And if it's to be said they did, and that therefore the loss of the commissioners' records had some materiality, that would all have had to be the subject of evidence and thus findings in fact.
Look, if you don't have it to hand, don't worry, but perhaps it could be supplied to us later.
Yes, so I think it's MS 830, my lord.
I'm sorry, I didn't hear the...
830.
830, thanks.
That's the letter of 9th April that begins that sequence. But for the reasons I've just touched upon in my submission, this whole issue goes nowhere because there would have had to be evidence and findings to show that there was some materiality to this.
Yeah.
The other thing to pick up in relation to something raised by my lord in the chair concerning the blue books and so on is that, and this is set out in the statement of facts and issues, it seems to be to some extent prayed against the commissioners as part of state fault. For a period of time there was a single VAT registration number.
Yes.
So it's only in a particular point in time that the individual boards assumed control of their own affairs and had separate VAT numbers and so on.
Yeah.
In any event, so far as the loss of evidence is concerned, which appears to be the weight of the submission for the taxpayer and the reasoning of the Inner House, those findings that I've taken the court to are, in my submission, the totality of what the first tier actually found about the non-availability of evidence. And as I said, that they basically just amount to a finding the taxpayer lost its own records.
VAT approvals, I mean, I'm just guessing, but I wonder if those are approvals of repayment.
I don't think that is what it is, my lord.
Well,
So,
well, there it is. If we, the stage for inquiring into the evidence
so
is long past.
well, indeed. Page 827, I should say, is the letter of 7th April from Liaison that sets out the initial request and what's described as HMRC records regarding approvals
For VAT claims, yes.
VAT claims for contracted out services, business activities and partial exemption, voluntary disclosure, corrections.
Yeah.
These are particular categories of their own.
Yes, well, presumably approvals for VAT claims are approvals for claims to reimbursement of input tax, are they not?
Yes, I think the context here is to do with a concern on the part of the commissioners as to whether any of this input tax had been recovered previously.
Yes, exactly.
But to step back and just endorse the observation that my lord and the chair made, if this was to have some importance in these proceedings, to show that there was state fault, that the commissioners had denied the taxpayer its ability to exercise its right of deduction, there would have to be findings in fact that the commissioners had done so.
Well, I take what you're saying. It doesn't look as though that's what this is about at all. It rather looks as though Liaison are wanting to check that insofar as input tax was paid, it hasn't already been reimbursed.
Yes, yes. But what it's become, in the opinion of the Inner House, is a loss of records that bears upon the taxpayer's present inability to prove his claim. And in my submission, that's just not made good. So I've mentioned then that that was the totality of the Inner House's, sort of the first year's treatment of loss of documents, and I've mentioned already that the other issue was to do with the fact that a claim was not made during the relevant periods, and I've indicated that's not state fault. I want to turn then finally to the opinion of the Inner House, and with a view to showing the significance that the Inner House placed upon the supposed effects of state fault, my submission is its entire approach really is infected by that. And it's the same three themes about state fault that one sees throughout the Inner House's opinion, that there was state fault in relation to the ability in law to deduct inputs, there was state fault in respect that claims were not made, and there was state fault in relation to the loss of evidence. Now, in relation to the statutory provisions, I've given the court my submission about the transient nature of the breach. But what the Inner House says about all of this is to be found, first of all, paragraph 12 on page MS 155. So there's a reference to the background of Marks and Spencer and then Fleming. Just above letter D, the court correctly records that the effect of that decision was that it was permissible to impose a reasonable time limit. If that was done retrospectively, transitional provisions had to be made that accorded with the principle of effectiveness. Correct, that is what the House of Lords held in Fleming. But then at paragraph 18 on page 157, letter C, in connection with the principle of effectiveness, what's said is the history of the taxpayer's activities indicates that the failure to reclaim input VAT on laboratory activities prior to 2006 resulted from a number of factors, including the failure of the United Kingdom to implement systematically the EU legislation on the recovery of input tax, and the practice followed within the NHS under direction from the Scottish Office not to reclaim input VAT on business activities. And that's a running together of two of the issues of state fault that I've mentioned. The position is then put in more stark terms by the First Division at paragraph 37 on page 164. So about 10 lines into that paragraph, again talking about the principle of effectiveness, there's a sentence beginning, the second of these factors is likely to be important in historical Fleming claims because an important reason for the taxpayer's failure to make a claim previously and to keep accounting and other records that would have supported such a claim will typically be that national legislation prevented claims for the recovery of input tax, notwithstanding the existence of the right to recover input tax in EU law. That is the case in the United Kingdom, and in our opinion, it is an important factor in the present case.
Which paragraph is that?
37 on page 164.
You say that's just wrong as a matter of law?
Yes. It's the transient breach to do with the failure to enact transitional provisions. And then at 38, the foot of that page, so still page 164, we think it important to bear in mind that in historical Fleming claims, the responsibility for failures to make the claims when full evidence was still available lies in considerable measure with the state in legislation that did not conform to the EU law right to recover input tax, and in the case of the United Kingdom, in the convoluted attempts to impose time limits on historical claims. So,
and that again, I think you say is just wrong in law.
Yes. There was a transient period when an issue arose in relation to the time limit absent transitional provisions. So all of that, in my submission, is wrong, but it infects the reasoning of the Inner House. So far as the failure to make claims in each of the periods is concerned, the Inner House discusses that at paragraph 8 on page 153. So just below letter J in paragraph 8, the Inner House narrates the fact that before 1994, the VAT liability of NH boards was handled by the Scottish Office, and that it was the general practice of public bodies not to make claims to recover input tax. Consequently, at that time, the general practice in relation to business supplies by NHS boards and other public bodies was that value-added tax was ignored. that practice changed subsequently.
That can't be right in the sense that they must have charged VAT to their business customers, didn't they?
Yes. This is
That's taking it a bit broadly.
This is specifically about the recovery of inputs. Yes. And what the court then says is, nevertheless, a major factor in the failure of the taxpayers' predecessors to recover input tax during the period down to 1994 was the manner in which government had organised the activities of health boards within the NHS and decisions made by government in relation to value-added tax on such activities. To which I say, fine, that's how central government was organising things, but it's not state fault that now allows this claim to proceed on the basis of inadequate evidence. The final aspect of state fault, the loss of evidence, if I can pick up quickly in relation to that. Paragraph 18 of the court's opinion on page MS 157. So just at letter B, or just between A and B, this is in connection with the principle of effectiveness, whether the exercise of the right is virtually impossible or excessively difficult. The second of these elements is obviously more significant in practice. What that part of the test entails is a form of proportionality exercise in which the national court must assess the difficulty of enforcing a community right. In doing so, the court must clearly have regard to both the evidence that is available and the reasons for any apparent deficiencies in that evidence. And as we'll see, that's then worked up into it's the state's fault that this evidence was missing. But of course, the inquiry that took place didn't address itself, at least through the prism of state fault, to the reasons that the evidence was not available.
At the bottom of, in paragraph 18, it's near the end, it says, history of, we think it of some importance in the present case, where the history of the taxpayer's activities indicates that the failure to reclaim input VAT on laboratory activities prior to 2006 resulted from a number of factors, including the failure of the United Kingdom to implement systematically the EU legislation on recovery of input tax.
Yes.
I don't know what support, if any, there could be for that proposition.
It's just wrong in my submission. It was the transient breach arising from the absence of transitional provisions. But these...
And if you ask if there had been such transitional provisions, would they have made a claim prior to 2008 or whenever it was changed? The answer is obviously not, since they weren't making claims for the current input tax, let alone for historic rebates. From
1994, the position is they didn't. They didn't make claims, and they could have made claims. Therefore, again, there's an elementary problem in arriving at the conclusion for which the Inner House contended. Lady, I'm conscious it's now 1 o'clock. I had hoped I would finish at 1. Not much to go, but I suspect it's best to rise at this particular moment.
Yes, it's always wise to allow yourself the adjournment to consider your position before you
quite so
sit down. Very well, we'll adjourn and resume at 2 o'clock.